Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. This week we are talking about the issue of labor relations, and certainly that applies to anyone in America that is engaged in business activity now, and it has become increasingly a more important issue to those who have a lot of employees. And of course, many of you that are watching this are in that field, and you understand how difficult it can be sometimes dealing with employee relations, and now of course dealing with the federal government. And an acronym that has kind of come to the forefront, and we'll talk about that in just a minute, is NLRB. And I'm going to have my guest explain that, so this is the perfect time to introduce my guest. First, we'll start with Bob Sullivan, who is the president of R.G. Sullivan Consulting, specializing in labor and employment consulting. Thank you for being with us, Bob. And Laura Lee Blake, who many of you may already know. She is the vice president of fair franchising and government affairs and general counsel. So she wears a lot of hats. She doesn't have any hats on today, but she wears a lot of hats with the Asian American Hotel Owners Association. So NLRB, this is an acronym that has been in the news lately, and to employers who have had to deal in this area, they certainly know what it is, but to some of our viewers who have they've heard this term before but don't know what that means. Bob, what is NLRB?
It stands for the National Labor Relations Board, and the board is a federal agency that consists of 5 board members, and they exist by virtue of the National Labor Relations Act, or NLRA, which I'm sure your guests hear a lot about as well. So it's, in theory, a 5-member board. Members are appointed by the president, subject to confirmation by the Senate. At present, there are only 3 members on the board, and there are 2 vacancies.
And just to follow up on that a little bit, because I know you deal in this area, I looked up on Wikipedia. I mean, I knew what NLRB stood for, but I wanted to get a better idea of what they actually did or what was their authorization. And it says they are to be an independent agency charged with holding elections for unionization and investigating unfair labor practices. Is that an accurate description of what they're supposed to do?
It is, and those are the 2 primary things that the board does. When employees there can be lots of different types of union elections, but when a petition for election is filed or when an unfair labor practice charge is filed with the board, that essentially is what allows the board to go forward and take action.
All right, and Laura Lee, so the NLRB, they're engaged in making sure that there are fair elections, or that workers can unionize if they wish. And they're supposed to look into these unfair business practices or labor practices. But what does it mean from an employer standpoint? I mean, what does an employer have to worry about with the NLRB?
Well, with this particular NLRB, as we've been examining what they've been doing recently, it's become more of a concern for many employers. And we will get into this discussion in a few minutes, but President Obama, each president is allowed to appoint certain members to the NLRB, and they're allowed to usually appoint up to 3 of their own party and 2 of the other party. Now this particular point, there's vacancies, but with President Obama, since he's taken over, he's taken a very aggressive stance with the NLRB and has appointed a few very key members who are strong Democrats and have taken very aggressive positions with employers. For an employer viewpoint, if suddenly your employees decide that they want to unionize, the NLRB would typically be responsible for overseeing the election process, making sure that it was fair and making sure that you were following the rules and there were no unlawful practices by either side. But at this particular time, the NLRB is getting much more involved with the employment practices, and it's raising many concerns for employers that we can discuss here today.
Now, I looked back, and it was created in 1934, and if you historically think about what was happening in the United States in 1934, you had a lot of issues with labor. You had massively high unemployment. We're in the Great Depression, and there seemed to be a lot of government activism going on at that time. Of course, prior to that, historically, I would suggest that maybe the needs for labor unions went around the issues of you had unsafe working conditions and items like that. I'm not sure that those who in 1934 created this, the National Labor Relations Act, ever thought we'd be where we are today. But as with so many appointments, I mean, this board, if you want to get a sense of how important they are and their role and how contentious it has become, with so many of these appointments, it has to get confirmed by the Senate, and it's just simply not happening. George Bush, under his administration, the 5-member board actually shrunk down to 2 because he hadn't been able to successfully appoint anybody, correct?
That's right. Excuse me, that's right. The board did operate with only 2 members for a period of time. There was actually a court case that resulted in a ruling saying that a 2-member board doesn't have legal authority to act. So right now, the board is operating with 3 out of 5 members, and essentially that's the legal minimum for it to act.
So I guess their point was, if we don't have enough members, we still have to make some decisions, and they got down to 2 members, and they attempted to go with a 2-person board. They made decisions. What happened with those particular decisions?
Well, as a result of the court ruling, essentially they were nullified. After that, though, with a 3-member board, the board then sat down and went through the decisions that had been affected and essentially reconsidered them. So after a lot of legal wrangling, the field is more settled now. That said, as has been alluded to, this board is incredibly activist and slanted in favor of unionization and union rights and organizing. And that's the direction the board's going now.
To follow up on that, Laura Lee, so we had a situation where there were 2, and I can only assume that you had President Bush in the latter stages of his second term was dealing with the Democratic Congress or Democratic-controlled Senate, and therefore getting through his nominee may have been difficult. And now, of course, the Senate operates basically under a 60-vote rule. You have that situation in the Senate now where President Obama, for years, was attempting to place onto the board a somewhat controversial figure, a gentleman by the name of Craig Becker, who he was unable to get through the Senate, but placed him on the board in what's known as a recess appointment, which means that Congress is in recess, therefore he can appoint whomever he wants. That obviously has caused some concerns, particularly among employers, because Mr. Becker seems to be somewhat of a departure from the historical type board member who looked at this issue in a vaguely balanced way.
Yes, and just to set the stage, and I found this quite interesting, but since President Obama has taken office, Big Labor has visited the White House numerous times. It was reported that in 2009, the Service Employees International Union, SEIU, President Andy Stern visited the White House 38 times in 2009. In 2010 and 2011, so the last 2 years, the AFL-CIO president, Rich Trumka, has visited the White House at least 2 to 3 times every week. He's admitted that he's there. So there's clearly a connection between President Obama and Big Labor. President Obama, in his efforts to get appointments to the board, initially nominated Craig Becker to serve on the board. And it was interesting, just looking at some of these dates. February 9, 2010, the Senate did not confirm Becker's appointment. So Obama appointed him on March 27, 2010. And I just read the other day that apparently on February 1 of 2011, all 47 Republican senators actually sent a letter to President Obama asking him to withdraw Becker's nomination. So there is some controversy there. Let's talk a little bit about this controversy. Becker has been advocating for excluding employers from the unionization election process. So he really wants union elections, when the employees are gathering, deciding whether to form a union. He really has admitted that he does not want the employers to be involved. He does not want the employers to give their opinions, to give any input on what unionization might mean at the workplace. And so that has been his whole goal. There's actually a quote that I'll read to you from an article that came out for the Coalition for a Democratic Workplace. And this is a group that AAHOA has joined because of our concerns with what's going on with Craig Becker and the NLRB. And the Coalition for a Democratic Workplace, just to give some background, is a group of over 600 associations and organizations that have formed to fight some of these efforts by the NLRB to change the workplace environment. But according to this quote that was put on their website, Becker has advocated that the NLRB reverse over 60 years of well-settled law and make fundamental and radical changes to U.S. labor law and national labor relations policy without input from Congress. Among other things, Becker has written that the NLRB should eliminate the formal role of employers in union elections, and that this change could be achieved with almost no alteration of the statutory framework. Now, of course, if you take employers out of the election process, many of these elections will go unchallenged, and the employees will not be educated about what it really means, what dues they have to pay, what this means as far as whether the union will really be representing their interests and whether they'll get the benefits and the wages and the hours that they've been promised.
So we have begun the discussion on Mr. Becker, and we're going to continue the discussion not only on Mr. Becker but this particular board with the NLRB. We are talking about labor practices and how they may impact you, both at your individual business level and of course the nation as a whole. And we'll talk more about that coming up right after this. And welcome back. I'm Chip Rogers here on the AAHOA Educational Experience, and we are talking about labor issues. And in the first segment we spoke specifically about the National Labor Relations Board, and we closed out that first segment talking about Craig Becker, perhaps one of the most controversial figures to ever have been appointed to this board. And Bob, by the way, my guest, Bob Sullivan, Laura Lee Blake, thank you for being here with us. Bob, the National Labor Relations Board has been around now going on 80 years. I guess during that time period there has been some amount of controversy, but the board, I guess, was structured in a manner giving the president the authority to appoint 5 members, but it's supposed to be balanced 3 on one side, 2 on the other. We've kind of gotten away from that, and this board, particularly with Mr. Becker, appears to be moving in a direction that no National Labor Relations Board has ever moved before. I mean, it doesn't seem that the balance is there that we've seen historically.
That's correct. The board was originally established in the mid-30s under the National Labor Relations Act with a law called the Wagner Act. And at the time, the law was slanted in favor of union organizing. For a lot of reasons, by the late 1940s, Congress enacted the Taft-Hartley Act. What Taft-Hartley did was to, in addition to giving employees the right to organize and bargain collectively, it specifically added a provision saying, or to refrain from doing so. The amendment also added union unfair labor practices. So now unions as well as employers can be guilty of violating workers' rights. So the Taft-Hartley changes made the law much more balanced. Going forward, the NLRB has historically taken a position of neutrality. It's their job to enforce the law, to protect worker rights, both to organize and to refrain from organizing. And what's going on now, particularly with Craig Becker, is that the board is going in a direction that would effectively disregard the Taft-Hartley changes by making it easier for unions to organize employees, by trying to cut employers out of the picture. It's almost as if the board is just completely disregarding the Taft-Hartley amendments and another 60 years of precedent.
So their goal, I guess, would be to have, as Laura Lee spoke a moment ago, that if a union came into a non-unionized shop and said, we want to set up a union, is to allow the employer to have absolutely no role in even educating its employees, its very employees, on what this actually means for them.
That's right, and as Laura Lee alluded to, there's a great deal of value in that. In fact, the U.S. Supreme Court has said in multiple decisions that the process of deciding whether to join a union or not is important and depends on robust and strong dialogue between all of the parties concerned, including the union, the employees, and the employer. And as has been said, Mr. Becker is officially on record. He wrote a law review article back in the 1990s as saying, essentially, it's none of an employer's business whether its employees are unionized or not.
An interesting statement indeed. And Laura Lee, isn't this in a sense I mean, we have these, you know, I teach at schools all the time and talk about the three branches of government. You have the judicial branch, which is to judge the law, the executive branch, which is to execute the law, and the legislative branch, which is to legislate the law. But through these type practices in establishing the NLRB, you had the legislative branch grant some authority to the executive to do this, but this seems to be taking it to a new level where this board wants to completely circumvent the legislative role in the relationship between employers and employees, which historically in the United States has been an enormously important issue, and only one that the legislature can accurately decide, not the executive branch, which of course is not held accountable to the voters.
Right, and we are seeing some of this where a lot of our members will recognize the name EFCA, Employee Free Choice Act, and this was a bill that was, the main legislation was introduced back in 2009, and at the time Senator Edward Kennedy introduced it in the Senate, and a companion bill was introduced by Representative Miller out of California. And the concept behind the Employee Free Choice Act that they were hoping would pass in Congress was that it would take away the rights of employees to have a secret ballot election. And what I mean by that is they were going to give union organizers an opportunity to walk into a workplace, and for a lot of our members, what the concern was is they would walk into a workplace on Friday afternoon, talk to the employees and say, you know, we don't need to have a secret ballot election here, just sign on this postcard. And if we get enough signatures, if we get more than 50% of the signatures of the employees, we will be a union by Monday morning. And that means that we need to then meet with your employer. We'll talk to them about your wages and benefits. And this is what they were trying to pass through Congress. And part of the concern, the hallmark of the United States, the hallmark of our country is the ability to go and to vote your preference. It doesn't matter if you're electing a candidate to office or if you're deciding whether to unionize, you should have the ability to go and vote on it in secret so that no one can intimidate you. And that was the main concern, was that employees would be intimidated. You know, a union organizer would come in, they'd be surrounded by 10, 20, 30 of their co-workers who have already signed these cards, and the union organizer would say, Bob, are you going to sign this card? And if you said no, you didn't know what the ramifications would be for you. And the other concern about the Employee Free Choice Act was also the concept that if it was unionized, enough employees signed these cards, a union was, you know, the shop was declared to be unionized, they would then have to sit down with the employer and negotiate. And if they couldn't come to an agreement, eventually within 120 days, it would go to an arbitrator. And the arbitrator, who maybe knew nothing about hotels, operating hotels, would be making decisions on the wages of the employees, how many, you know, what the housekeepers would have to do as far as what units they would have to clean, how many would have to be cleaned in a day. So it raised a lot of concerns for our members, and AAHOA was one of many, many business associations, employers that fought this, and thankfully it did not pass Congress. But and so now we're starting to see where initially there was legislation that they were trying to get passed through Congress. That did not work, so now the NLRB is taking other action to really kind of go backdoor to accomplish some of their same goals, which is continuing to raise concerns in recent months.
And really that strikes at the heart of I think why so many people have problems with this, because the administration supported the Employee Free Choice Act, card check as most people know it, and that was defeated in the legislative process. So in a way they acknowledged we need to go through the legislative channel to make this happen. And when they were defeated, they said, well, why don't we just go around the legislature and use the executive branch to enact this through the NLRB? I mean, isn't that exactly what they're trying to do?
It is, and it's become common to hear the phrase administrative EFCA. And it's not just the NLRB. I'm sure we'll touch on some things that the Department of Labor is doing as well that go hand in hand with what the NLRB is trying to do. But it goes back to Craig Becker's agenda to make it easier for unions to organize groups of employees, despite the fact that these days unions win nearly 70% of all secret ballot elections. But that isn't good enough. There's a desire to bring that even higher and to increase overall union density.
I guess you know, the Pittsburgh Steelers can win the Super Bowl without winning every game. Every team doesn't have to be the 72 Miami Dolphins, right? All right, we have actually run out of time, but we're going to talk more about this particular issue in next week's show. So make sure you join us. For both Bob Sullivan and Laura Lee Blake, thank you for being with us today. I'm Chip Rogers, and if you'd like to contact me, you can reach me via email, chip@AAHOA.com, chip@AAHOA.com. Thanks for watching, and we'll see you again next week.